court does call the case versus Elizabeth Chuddick.
Here, emergency on behalf of Ms. Judith.
Chuddick, I think.
It is.
Go ahead, state your name.
Elizabeth Chudik.
I said it quietly, so as not to.
I know, I know as I was saying it, I'm like, that's wrong. Anyway. I have a plea form indicating defendant's going to plead to an added count 2 of attempted resisting instructing a police officer to 1-year offense. Upon our successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of it.
Sure.
Yes, Your Honor.
May I have her sworn?
And do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
So I do.
State your name, please.
Ma'am, it is this court's understanding that you're going to plead guilty to the charge of attempted resisting and obstructing a police officer. That is a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. You understand that?
Yes.
Still wish to plead guilty? And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
Signed in advice of rights form, is that correct?
Yes. Your Honor.
Any question regarding any of those rights? Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on there.
Yes, Your Honor.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Your Honor.
And also because you believe that you're guilty of this offense? February 16, 2026, Carpenter Road near Center Valley Drive, Pittsfield Township, Washtenaw County, state of Michigan. Did you come into contact with a police officer from Pittsfield Township Department of Public Safety?
Yes, Your Honor.
All right. What happened?
The police officer told me to get back in my car, and I said no.
What was happening at that moment?
He pulled me over. I was on my way to drop my car off at the tire place, to get my tire fixed.
Okay.
And then go to the movies with my kids. Sorry, Your Honor. So the police officer pulled me over. I was confused. I thought he was pulling over the car in front of me that didn't have a license plate. So I pulled into the tire place. I got out of my car. I'm a busy mom, so I just wanted to speak to the police officer. He yelled at me to get into my car, and I said no. And I asked him why he had pulled me over. He grabbed me, and I tried to get away.
Can we approach, Your Honor?
Yeah, I think we better. Also approach. Records reflect bench conference. Ma'am, were you aware at some point that the officer was pulling you over because your registration had expired?
I had no idea, Your Honor.
Okay. As you're sitting, why didn't you remain in the vehicle?
I was, like I said, I was running errands, and I honestly,
I understand that.
I don't.
The officer told you to remain in the vehicle. You didn't. Is that correct?
Well, I had gotten out because I, in my mind,
Let me ask it this way. Whether you got out beforehand, at some point, the officer told you to get back in your vehicle and remain in your vehicle, correct?
yes,
And you failed to follow that instruction. Is
correct.
that correct? All right. Ultimately, determined that the reason that the officer pulled you over was in regard to your registration.
I'm sorry, Your Honor, can you repeat?
Ultimately, you determined that the reason that the officer pulled you over was in reference to your registration.
Eventually, I did not know that before.
Didn't ask that.
Yes,
Ultimately, you realized that.
yes, Your Honor.
So under all of those circumstances, you would agree that the officer's command for you to get back in your vehicle and remain in your vehicle was a lawful command for you.
Yes, Your Honor.
All right. And that you refused to follow that.
Yes, Your Honor.
Ma'am, if I accept your plea and you commit misconduct between the time of my acceptance of your plea and the time of sentencing, you would not be permitted to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, Your Honor.
Counsel, are you aware of any of the promises, threats, or other inducements which have led to this plea?
No, Your Honor.
Yeah, Your Honor.
Have I complied with the court?
You are satisfied.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count two. Count one is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be
May 13th at 9 a.m.
May 13th, 2026, 9 a.m. Before me. Bond will continue. Thank you.
Thank you, Your Honor.
Ma'am, on your way out on the left, about 2/3 of the way down the hallway is my probation department. Stop in there and get instructions so the sentencing process can begin.
Okay, thank you, Your Honor.
Thank you. The case of the people of the state of Michigan versus Michael Bank.
Good morning, Your Honor. Jake Kennedy, on behalf of the people.
Morning.
Your Honor, Michael Gaddy, Assistant Public Defender on behalf of Mr. Bank, who is with us via Zoom. If you could state your name, Mr. Bank.
Michael Bank.
Thank you, sir.
Your Honor, I'd ask the court for maybe a 2-week adjournment in this matter if the court would deem fit. I did meet with Mr. Bank via the video visitation method from Oakland County. It's I believe that given the nature of this file, we need to meet with him in person. It's time limited and the sound isn't very good.
All right. Any objection? No. Probable cause conference, April 30th, 2026, 9 a.m. Bond continues.
Thank you. I'll come visit you, Mr. Bank.
Mr. Bank.
Okay. Appreciate it, Your Honor.
Court does call the case. People versus Deshaun Gainey. Gainey?
Yes, I'm here.
Yes, I got you. I'm trying to get your attorney to give me an appearance. Hang on a second, sir.
Joy Gaines, Senior Assistant Public Defender. Good morning, Your Honor.
Mr. Gainey, can you state your name, please, sir?
Deshaun.
Thank you. All right, what do we do?
Your Honor, at this time, at this time, we would ask for an adjournment so that we could make arrangements to meet with Mr. Gainey in the Department of Corrections.
Yeah, is there going to be a problem with JCF in terms of getting in to meet him, or?
I would ask for 3 weeks. I have not worked with this facility yet.
Probable cause conference without objection will be adjourned May 7th, 2026, 9 a.m. Bound in this matter will.
Michelle's case.
Thank you. And I'll need a green sheet.
Yes.
Thank you, Mr. Gaines. Court does call the case People versus Ryan Milligan.
Joy Gaines, Senior Assistant Public Defender representing Mr. Milligan. Your Honor, I've had an opportunity to discuss this case with Mr. Milligan as well as with Ms. Cinda and the circuit court attorneys who will be handling his case before Judge Slay. At this time, the prosecutor has agreed to a sentence agreement upon a successful plea to guilty as charged. Mr. Milligan they would agree that Mr. Milligan's sentence would be credit for time served, no additional incarceration. In talking to my colleagues in circuit court, we're going to waive that in order to secure that also with Judge Slay and are asking for a pretrial date.
That's correct, Your Honor.
All right. Mr. Milligan, you're going to waive your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes, sir.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir, Mr. Simpson.
All right. People also waive their right.
Thank you, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count. Ms. Gaines.
Your Honor, we acknowledge receipt of the information, waive its reading on the record. At this time, my client will stand mute and enter a not guilty plea.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial in this matter,
April 30th at 1:30 was Judge Slay.
April 30th, 2026, 1:30, Judge Slay.
Thank you.
Thank you.
And will continue. Thank you, sir.
Thank you, Mr. Milligan.
Thank you.
Yeah. Court does call the case of the person. Cheedra. Hold on. Ikiji.
Good morning, Your Honor. Can you have the people?
Good morning, Your Honor. Jonathan Sachs for Mr. Ikeji for his case ending in 1678.
And
Mr.
Assistant
Ikeji's coming out now.
Public Defender Jay Bellinger on behalf of Mr. Ikeji on all the remaining matters, Your Honor.
All right, what are we doing?
Your Honor, may we request, and it's for all four cases, a 1-week adjournment. When we were here last time, we had thought and the prosecution had agreed to a mental health court disposition. Unfortunately, between now and then, he was not accepted into mental health court. And so we are working out what we hope will be a HIDA disposition, but we need 1 more week just to figure everything out.
Is everything going to be able to be figured out in a week? I don't want to get here in a week and then be adjourned again.
Your Honor, I'm optimistic that we will get there in a week.
I appreciate your optimism. That doesn't answer my question.
I do think we're nearing a resolution. We have several matters that we're trying to sort of get together in one big global.
We about to tear.
I know. What was that? Oh, okay, never mind. I just thought all in this with us. Mr. Bellinger, do you think a week's gonna do it?
Your Honor, I do. Based on our conversations, it sounds like we may be waiving everything up as early as next week. So I believe a week would be just fine.
Probable cause conference, April 23rd, 2026, 9 a.m. Bond continued.
Your Honor, could I ask to address bond?
Yes.
So it's been over 180 days for Mr. Ikeji. Certainly, if it's a HIDA disposition, that's more time than we would expect to see there, significantly more time. He is doing extremely well. Mr. Bellany and I have both observed the changes since we first met him several months ago and where he is now, as has the Forensic Center with their prior evaluation, their more recent evaluations. There actually is a finding there of not guilty by reason of insanity if he were to pursue that route. His family is extremely supportive. Both his mom and his dad are here today. And I'm confident based on my meetings that he would do well on our request is home confinement. He would continue to get the medications he's getting. He'd work with community mental health services. And due to the amount of time he spent and how well he's doing, that's our request.
Anything else from anybody else?
No, it's for court.
No, Your Honor.
All right. I won't consider it next week, but I'm not gonna do anything now. Motion for bond reduction denied.
Thank you.
Court calls case People versus Allen Folks.
Ashley Feltus for the people.
Good morning, Your Honor. Wendy Barnwell, P42-505, on behalf of Mr. Folks, who is in the courtroom.
Yes, he is.
And good morning, Miss Barnwell. Long time no see.
Yes, Judge.
Your name, sir?
Alan Folks, Your Honor.
All right, what are we doing on this case?
Your Honor, I'm requesting a preliminary examination. I do have
right.
electronic and paper discovery.
All right, thank you. My date is the
April 28th.
people also, will they have your witnesses available on the 28th?
Try for that date, Your Honor.
Preliminary examination in person for 28th, 2026.
Your
9
Honor, I
a.m.
do have, sorry about that. I do have
I should have known.
another, Well, it's in downtown Ann Arbor, but I think I could zoom on that one. I think so. That's a sentencing.
Oh, you've
one
got something
second.
in downtown Ann Arbor that you think you might
Yeah.
need to zoom in. Okay,
I'll zoom
think we
into
can-
that one, but I'll come physically in for this one.
all right, very good. 28th, 2026, 9 a.m. before Judge Barr.
Thank you, Your Honor.
Bond continued. Thank you.
Same courthouse, Mr. Folks, same courthouse.
This
We'll
one.
talk. Thank you,
You
Judge.
said-
Have a good day, everybody.
All right, you do the same, Ms. Burnham.
Yes.
Courthouse called the case, People versus Devon Thompson.
Ashley Feltus for the people.
Morning, Your Honor. Marcia Krejci on behalf of Mr. Thompson, who's approaching.
Your name?
Dave Thompson.
Thank you.
Your Honor, we have two requests today. The first request is we'd like to proceed to preliminary exam. I believe discovery is complete. We have a sort of a special thing in mind that,
That's correct, Your Honor. The defendant's co-defendant, Boston Henning, is already set for preliminary examination on a special setting before Judge Freshour. And I would request. that-
Okay, what date is that?
It's April the 29th at 1 p.m. at the 1484 District Courthouse.
That's the co-defendant to this case.
That's correct. And
Fresh hour, know it's coming.
I believe so. I was emailing with Ms. Ostrowski yesterday about this.
that date came about with the meeting that we had with Judge Freshour.
All right. And I'm presuming then the people would have their witnesses available.
We'll do our best, Your Honor.
All right. Preliminary examination, April 29th, 2026. What, good at
1 p.m., Your Honor.
1 p.m.
The second request comes from my client. He would like me to address bond briefly.
Go ahead.
Okay. My client stands before you, a young man who was 17 when this incident allegedly occurred. I believe his criminal history at the juvenile is pretty, I think he's got a CCW, if I'm not mistaken. But after that, there's nothing else. He does have family in the area. He's resided here his whole life. He explains to me that he'd be able to currently reside with his grandmother in Ypsilanti, and that he is needed to help with childcare of his younger siblings. And so he's asking that the court allow him 10%. If the court does, we'll be asking for a PR bond in this matter. He'd be willing to do a house arrest on Tether. That's our request today.
Your Honor, the defendant was involved in the planning and execution of an armed robbery where the item to be stolen was a firearm or firearms. The defendant has 2 firearm-related charges, CCW and reckless use of a firearm while juvenile in 2025 and 2024 respectively. In this case, a victim and a co-conspirator were both shot. So I do believe the cash bond that is appropriate.
So 2 people got shot in this whole ordeal. Motion for bond reduction denied. Bond will continue.
Thank you, Your Honor.
Court does call the case of the People versus Aaron Brandon.
Alexander on behalf of the people.
Albert Burdell on behalf of Mr. Brandon, who should be appearing by Zoom. Oh, Mr. Brandon. Thank you. Here we go.
Evidence amended. This should have been charges out of the officer defense rather than police prepared a to expect domestic violence charge. Then I'm intending to move to dismiss count 2, which is arraigned on or add the count 3 of the proper domestic violence charge. And I did send that.
Any objection to that, Mr.?
No, Your Honor.
This time I will dismiss count 2. We will do the arraignment on then the count.
Stand mute, waive formal reading.
All right. Bennett, waive formal reading and standing mute for will enter not guilty, please.
As to the probable cause conference today, just asking for an adjournment. I was just appointed very recently. I have my green sheet here for to hand to your deputy.
Probable cause conference will be adjourned to May 7th, 2026 night. But let's bond continue. Thank you.
Especially on the way.
Court calls case People versus George Wright.
Anderson on behalf, with your honor.
Moving on to Marcia Patron on behalf of Mr. Wright, who's approaching. Bless you. Bless you again.
All right. Your name, sir?
George Willis Wright.
Thank you.
Your Honor, we'd be requesting a preliminary exam in this matter.
You have all discovery.
Yes, I do, Your Honor.
Your other witnesses available the 28th. Preliminary examination person at the 28th, 2026, 9 a.m. before me.
Your Honor, my client is asking me to make a request to for a PR bond, if I may, briefly.
Briefly.
So, Your Honor, my client stands before you. His last convict, I believe, for any crime was in 2024. Further, most notably is my client has some health issues that require some surgery. The first one is some eye issues that requires surgery at the Kellogg Eye Center, which he tells me he has surgery scheduled for April 20. Is that correct?
Yes.
Okay, and that he also needs to follow up with a surgery in his abdomen that requires follow-up. He has been able to secure housing at Miller Manor that so he has no family there in the area to help him. Therefore, he needs to be out and about. Specifically, he needs to be able to get to his bank account for bond. What I'm being told by my client is, if the court is unwilling to reduce the bond, is that his phone privileges have been prohibited. I don't know if that's true or not, but because I haven't been able to research that through the jail, but he's asking to have phone privileges. So if the court is unwilling to give him a PR bond, then the court would be, he can then make arrangements with a bail bondsman.
Wrong.
Your Honor, at this time, the people are going to be objecting. This is the case was strangled by the defendant to the point of unconsciousness and wants to make sure the defendant will plead it. Give the very lengthy history of domestic violence, including a DV conviction in 2010, 2 FAs from 2015, a DV conviction in 2019, and ongoing aggravated DV from 2019 for the 2023 domestic violence conviction, along with the dismiss DV third from 2025. So at this point, I'm objecting. As to the phone privileges, I don't recall that being revoked. I don't believe that was addressed at arraignment. So
I don't see that. I ordered it. So I don't.
Right. My client says it's from a previous incident case that it was convicted, but if it is, then I guess a stipulated order from the court.
I'm not stipulating any. I don't know why they're revoked. It may be proper that they are revoked because I contact the victim. So I'm not going to agree to anything regarding that. You can talk to the prosecutor about that.
Right. All right.
With it, but I'm not agreeing. I want to make it clear. I'm not agreeing to restore anything.
Sure.
Motion for bond reductions denied. Bond will continue.
Thank you, Your Honor. Bond reduction denied.
Court calls case People versus Robert Laster.
Ashley Feltus for the people.
Kyle Burdell, excuse me, Kyle Burdell on behalf of Mr. Laster, who's approaching the podium.
Michael Gaddy on behalf of Mr. Laster, 23 F 1486 and 1117.
Just attorney and a bond argument and a request.
How you doing, Justin?
Your name?
Robert Laster, Justin.
Doing.
Your Honor, on my case, at least, and it's my understanding, based on what's in Mr. Gaddy's hand, we are both asking for adjournment at this time. I do have a bond request from the court. Would like to hear it.
That's correct, Your Honor. I think it'd be prudent to keep all three together.
May 7th, 2026, 9 a.m. Esteban.
Your Honor, Mr. Laster,
May I approach, Judge?
sorry, want to approach? Oh, is it just a hand on the
Just a
phone?
hand in the.
Oh, sure. Your Honor, as to the bond request, so Mr. Laster lives in Mississippi. He's currently basically couch crashing with a friend. And so his bond has already been modified from community corrections, or his community corrections already has instructions to allow him to test locally where he's at. But at this point, it's my understanding that he does not have permission to leave the state. So we just ask that he be allowed to return to his family. He has a 10-year-old daughter and an 8-year-old grandson back home in Mississippi that he needs to get home back to and take care of.
So first thing though is that he corrected the community corrections violations.
That is correct, Your Honor. He went and tested this morning. I spoke to him
Thank you,
yesterday.
Judge Simpson.
I went and spoke to him yesterday. He called yesterday before duty. Immediately after I informed him of the issue.
And I'll echo the same as Mr. Gaddy. He was very apologetic and Mr. Laster was very apologetic and eager to correct his misstep and his oversight.
Response from the people.
Your Honor, Selton has gotten he did his initial test. I don't know if we have those results yet. If it was just this morning, that would be something I might be interested in
Before
we.
any agreement.
Yeah, just because there was that bond violation, not going to test for almost a week. Maybe a week, actually, now that I think about it, it was the money.
Motion for bond modification. All right, bond will continue as it's, as you can't leave the city.
Understood.
Thank you.
State your apologies.
7.
Thank you.
Oh,
Thank you, Your Honor.
Thank you, Your Honor.
court calls the case, people versus Tanisha Moore.
People, Your Honor.
Perfect. Kyle Burdell standing in for attorney of record Bill Amadeo on behalf of Miss Moore.
Your name?
Tanisha Moore.
Objection to Mr. Burdell stepping in.
Standing in on behalf of Mr. Amadeo today.
Oh,
Is that all right?
that's true.
No? All right.
No objections. Thank you. So, Your Honor, at this point, it's my understanding that the parties are working on a resolution. I have the green sheet for your deputy.
Probable cause conference will be adjourned without objection to April 30th, 2026.
Thank you, Judge.
Bond continue.
Bill will be in watch.
Okay, thank you.
Thank you.
Court does call the case, people versus Lewis McSwain.
Special focus for the people.
Kyle Burdell on behalf of Swain, standing in for attorney of record Bill Amadeo.
Be here.
I don't believe he is, Judge, unless he's on Zoom. Mr. Amadeo has been attempting to contact him, but I cannot explain his absence here today.
Swain. On bench warrant will issue for defendant's failure to bond is set in the amount of $10,000 cash shirt. Will issue immediately.
Understood. Thank you, Judge.
Court does call the case for people versus Walter Rice.
Your Honor.
Bring in.
Trees. Mr. He's Oster. From the bottom.
All right. Counsel for defense state their appearance. We don't have him here anyway, right?
A reference.
Pass this matter.
I'm sorry, I'm here. I'm filling in for attorney Max Dubin.
Do you know where your client is? We
Yes, he's at in custody.
don't.
And I did not see them on Zoom.
You're right. But he's not here. We don't know where he is. Is that right?
Uh,
Yes, that is correct.
He is in custody in Macomb County Jail.
Oh, well, that explains it. He's not in custody here. He's in
Correct.
Macomb.
Yes, so he should be on Zoom.
No, because I don't think the writ was done. No writ was done because we did not know that he was located in Macomb County.
Okay.
So I will adjourn the probable cause hearing. Do you know how long he's intending on being in Macomb?
I do not.
I'll adjourn the probable cause hearing till the 30th, so the writ can be prepared and then we'll proceed from there.
Thank you so much, Judge.
2026, 9 a.m. bond continued.
Thank you, Judge.
Thank you. Court calls case People versus Justin Chavez.
Yes, Your Honor.
PAGs. Oh, there she is.
Good morning, Your Honor.
Good morning. State your appearance, please.
Carrie Angie on behalf of the Attorney General's office.
Thank you.
And Stephanie Canna on behalf of Mr. Chavez. And I believe you by Zoom.
Chavis.
I don't have an intern anymore.
I know. I wasn't used to hearing your voice.
It's gonna be me.
It was a pleasant respite.
It was respite.
All right.
Could you please state the name?
What's it?
I think
Pardon
you
me?
said it. You're
Yeah, what's your name?
Justin Chavis. Sorry, the sound is so choppy right now. It's hard for me to hear.
Okay, no, it's okay. You're good. It's your attorney.
It is. It 1000% is. And Your Honor, we are asking for an adjournment. I did receive the offer yesterday, but we still don't have discovery, and I will get you a green sheet. Again, I don't have
You
it.
don't have a green sheet?
I don't have an
You don't
intern.
have an intern? You don't have a green sheet?
I know.
You don't know how to do anything.
I'm struggling. I'm struggling.
Baby.
Without objection, I will adjourn this to April 30, 2026, 9 a.m.
Thank you, Your Honor.
All right, bond will continue. Said it for the AG.
Thank
That's
you, Your
it?
Honor.
Thank you. Have a great day.
Likewise.
Court does call the case. People versus Kurt Bushline.
Good morning, Your Honor. J. Grant Miller, P58658 on behalf of Mr. Bushline.
Your name, sir?
Kurt Bushline.
Thank you. What are we doing?
Your Honor, I believe, have a plea in theory. I just didn't receive a form for Mr. Chebalowski, who is not present today. I know Ms. Feltis was covering it and we were emailing last night. It's to plead a use, Your Honor. I just didn't get the form.
You. Ms.
I
Feltus,
apologize.
I know you're trying to cover a lot, so
I
I
wasn't
get.
clear on that from our email exchange that we were doing the plea today. So I apologize for not understanding that accurately. So I would request an adjournment of 1 week so we can get that done with the court's grace. Thank you.
I'll adjourn it out 1 week. April 23rd, 2026, 9 a.m. Bond continue.
Thank you, Your Honor. Thank you, Ms. Feltis.
Court calls case People versus Rashad Harshik.
Yeah.
Best I could. There's a lot of letters.
Agreed. Ready, Judge. Torres Feaster, Assistant Public Defender on behalf of my client. Please state your name for the record.
And try. Okay, go ahead. What's your name, sir?
Riyadh Zarpazic, Hadj Zarpazic.
Yeah, what he said.
Okay. No. All right. What are we doing?
Thank you, Judge. The last time we were here, I believe my client was in custody in a different county, and so we weren't able to address the matter, but it's been resolved now. So this is our first real PCC.
Got it.
One adjournment, Judge, so we can talk to the client and the people and see about a potential resolution.
Probable cause conference, 7/2026, 9 a.m. Bond on this will continue, and you don't have a green sheet because Cannon was supposed to do it, right?
She was, Judge.
Okay.
All
right. Oh, we'll wait. All right. Thank you.
Thank you, Your Honor.
Yeah, Judge.
Court calls the case People versus Jason Bryant.
Morning, Judge. Brian Bowling on behalf of Mr. Bryant. How you doing?
Can you take the record, please?
Jason Bryant.
Thank you. Judge, we're asking that this matter be set for an examination. I believe all discovery to be complete.
People have their witnesses available the 28th.
Your Honor.
Preliminary examination in person, April 28th, 2026, 9 a.m. before Judge Barr. Bond will continue.
Thank you, Your Honor.
Thank you. Court does call the case of the versus John Allen.
Yeah, so we have. Your Honor.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Mr. Allen.
Your name, sir?
Dion Allen, sir.
Thank you.
Your Honor, we are requesting a preliminary examination, and we are also would like to address bond condition.
Discovery is complete.
That's my understanding.
People have their witnesses available 28th. Preliminary examination in person, April 28th, 2026, 9 a.m. before me. As the bond.
Your Honor, it's my understanding that Mr. Allen is on GPS tether. We are requesting either the removal of the tether or a change in the exclusion hot zone from the address based on, it's our understanding, and Ms. Mackey did reach out to Ms. Zinda to confirm that the complainant is no longer at the hot zone address.
No, she will be at that address until, so I would be objecting to any modification of that until she is actually arrested.
Motion for modification is denied, given those circumstances. Continue. Thank you. Court does call the case of the people versus Kimberly Douglas.
People.
Assistant Public Defender Chelsea Virgil with and on behalf of Kimberly Douglas.
Hello, Ms. Virgios. It's been a while.
Good morning. It has. Can you state your name?
Kimberly Douglas.
Good to see you, Your Honor. We are asking for an adjournment in this case. She has a pretrial in circuit court on April 23rd, so we ask for a date after that.
Okay. Probable cause conference without objection, April 30th, 2026, 9 a.m. Bond continued. Thank you. Court calls case people versus M.I.A. Outside. Got it. I was close.
Good.
All right.
You said perfectly.
Yeah.
Stephanie Cannon, on behalf of Mr. City.
That's exciting.
All right. I have before me a plea form that indicates that he's going to plead guilty to the charge of disturbing the peace of 90-day offense. Upon a successful plea to that charge, count one would be dismissed. That's the court's full understanding of it.
Yes, Your Honor.
Yes, Your Honor, that is my complete and full understanding.
May I have him sworn?
Right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, and nothing but?
Yes, sir.
Name, please.
That's exciting.
All right. Put your hand down. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of disturbing the peace. That is a misdemeanor punishable by up to 90 days, $500 fine plus court cost. Do you understand that?
Yes, Your Honor.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court. You understand that? All right. Still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Good.
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
Signed an advice of rights form, is that correct?
Sure.
Any question regarding any of those rights?
Oh, Your Honor.
Please look at paragraph 5. You'll see that copy shot on the podium, the rights which are part of a trial. And by pleading guilty, you'll be giving up those rights as well as all the rights on that.
Yes, Your Honor.
Then you're giving up your right to appeal outright.
Yes, Your Honor.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
Doing this voluntarily and of your own free will?
Yes, Your Honor.
And also because you believe that you are indeed guilty?
Yes.
On the date of September 14th, 2025, at the location of 516 East Liberty Street, City of Ann Arbor, Washington County, State of Michigan, were you out in public?
Yes, Your Honor.
And was there a disturbance?
Yes, Your Honor.
Okay, what happened?
We're out of a bar and we're all with friends and stuff, and we made like a lot
of noise.
Yes, sir.
And that it disturbed the peace and repose of the area immediately surrounding you. Sir, if I accept your plea, I do have to advise you if you commit misconduct between the time of my acceptance of your plea and the time of sentencing, you would not be entitled to withdraw your plea and the court would not be bound by any sentence recommendation or evaluation. You understand that?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
Your Honor. I'm aware of none, Your Honor.
And have I complied with the court rule?
I'm satisfied, Your Honor.
Yes, Your Honor, I'm satisfied.
Court will accept the defendant's plea guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court. Probation sentencing will be
May 8th at 8:30.
May 8, 2026, 8:30 before Judge Perry. Bond will continue.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls the case of the people versus Russell Gull.
Feltus for the people.
Good morning, Your Honor. Assistant Public Defender Davey Leave on behalf of Mr. Gal. Gal, can you tell the judge your name, sir?
Russell Gull.
And Your Honor, I'd like to set this matter for preliminary examination, please. Discovery is complete.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available the 28th.
You can track them, Your Honor.
All right. Preliminary examination will be set April 28, 2026, 9 a.m. before Judge Barr.
Thank you.
Bond will continue. Thank you. Court does call the case of the people versus Melinda Baker.
Feltus for the people.
Michael Gaddy, Assistant Public Defender on behalf of Ms. Baker, Your Honor. He is here by Zoom.
Oh, there she is. Ms. Baker, can you state your name, please?
Melinda Baker.
Thank you.
Your Honor, may we approach very briefly?
Yes. Yes.
Why are they approaching? I don't like it.
Record should reflect we've had a brief bench conference in this case. Circumstances of this, I'll adjourn probable cause conference to May 21st, 2026, 9 a.m.
I'll be in contact.
Thank you.
Court calls the case people versus Edward Harvey.
Ellie's on behalf of the people, Your Honor.
Assistant Public Defender Davey Leave on behalf of Mr. Harvey. Mr. Harvey, can you tell the court your name, please?
You can say it.
No, you need to say your name, sir.
Sir, what is your name?
Harvey.
Your full name?
Edward Harvey.
Thank you. What are we doing?
Your Honor, I'd like to set this matter for preliminary examination, please.
Yes, so discovery is complete.
It is not, Your Honor. We're still waiting on receiving some body camera. Harvey's indicated to me that he would not like to waive any timeframes and would like to set this matter.
All right, but he understands also that if that does not appear, it's not going to be the basis for an adjournment.
He does understand that I did review those, Mr. Harvey.
We'll have their witnesses available on the 28th.
I did reach out to the sheriff's department about the body camera. I heard back, but I think I need to do a little bit more discussions.
Preliminary examination will be set April 28th, 2026, 9 a.m. That's before me.
Thank you.
As to bond.
Mentioned that the party has contacted a number that the victim is using 16 times from and how he knows the number for the victim is she's referred to as his wife. He loves her, begging for her forgiveness. So at this point, I'm going to be asking for his calls and texts to be revoked. He talks about what might happen with the case, if they come to court, if they don't come to court. So at this point, I'll ask for his calls and texts to be revoked.
That's any response.
No, this is my first time hearing about this.
It's not too hard. Well, we'll get that to him. And at this point, I'm going to revoke the defendant's phone and texting privileges from the Washington County Jail. Right. Thank you. Court calls case People versus Shelby Barber.
People, Your Honor.
Brother Judge, court shall cease to assistant public defender on behalf of Shelby Barber. Please
Your
take.
name?
Shelby Barber.
Thank you.
Well, thank you, Judge. According to our notes in the file, it looks like we are missing a second police report in this file. And so we're going to be requesting an adjournment so that we can get that second police report.
You know anything about that?
Yeah, Your Honor, my understanding is that the report is included in the media notice on this file, but I could get routed to counsel in a different way.
It's a different.
Thank
Okay.
you so much. Appreciate it. Thank you.
All right. I will adjourn May 7th, 2026, 9 a.m.
Thank you, Your Honor.
All right.
Thank you, Judge. Be in touch.
Court calls case People versus Larry Passaru.
Brian Bowling on behalf of Mr. Casaru, Your Honor. Can you state your name for the record, please?
Larry Kazaru.
Your Honor, I'm asking for a preliminary examination in this matter. I believe all discovery to be complete.
All right. People have their witnesses available on the 28th.
Well, Your Honor, there is one uncharged case, which I think would be a misdemeanor that's slightly related to this. So I'll work on getting that police report disclosed to defense before that date, just so they have absolutely everything. But I think as far as the full purpose of this case, we do have everything disclosed. There's just one more thing I'll get over there. Right.
All right.
That is my understanding. Thanks, Judge.
Preliminary examination, April 28th, 2026, 9 a.m. That's before Judge Barr.
Thank you, Your Honor. Thank you, Brian.
Court calls the case People versus Manuel Brandhouse.
Here, Your Honor.
Your Honor.
Stephanie Hanna on behalf of Mr. Brandthouse, who is appearing by Zoom for Barnhouse. Mr. Barnhouse, could you please state your name for the record?
Manuel Barnhouse.
Your Honor, we're just asking that this be set for a preliminary exam. Oh, and we also have to arraign him on the additional charge.
Yes, on the additional charges counts 4 through 7. Have you gone through that with him?
Your Honor, I have emailed him the information and we discussed it best.
All right. And so as to the arraignment on counts 4 through 7?
Your Honor, my client would stand mute and ask for his next court hearing.
All right.
And we would waive the formal reading.
Defendant standing mute, or waiving formal reading, standing mute. Court will enter a not guilty plea as counts 4 through. I will want to set for preliminary.
Yes, Your Honor.
Right. Would you be ready to go with those amended counts on the 28th?
Your Honor, it's my understanding that paperwork, yes, they've already given me what they have regarding, and I'm not anticipating any additional discovery.
Your Honor, based on the nature of the new offenses, should counsel wish to review those prior to the examination, we would need to set up meeting with thoughts that's taking place. So I don't know if that's necessarily.
So that doesn't sound like discovery is complete.
Your Honor,
Wants to do that sometimes. Doesn't want to do that. It's.
I was provided with a packet of the download from your other counsel. If additional discovery has been created, please let me know.
And based upon the offenses.
Then yes, Your Honor.
And yes, Your Honor, what?
Yes, Your Honor, we'll ask for another PCC date.
That's probably wise. All right. Probable cause conference will be adjourned to May 7th, 2026. 9 a.m. Bond will continue. Thank you, sir.
Thank you, Your Honor.
Cannon, you really are having problems without a. No, you don't have to explain.
I did ask the other attorney if there was anything in addition to what he had provided me. He said no, but I'm getting information from Mr. So that's fine.
Who said no?
We'll work it out amongst ourselves.
Who said no? Well, you're just ignoring me now. You're not even talking to me. I'm not here to embarrass you. I will, but I'm not. You know what? She's not even attention, not even paying attention. Not even fine. No, you're not. I'm done with you. Courthouse case, Drew versus Cameron Larry.
Then we have.
Public Defender John V. Leave on behalf of Mr. Larry. Mr. Larry, can you tell the judge your name, sir? Cameron Larry. And Your Honor, I do have a green sheet. I'd like to request an adjournment in order to just receive some additional discovery.
Any objection?
No, Your Honor, the additional discovery is new jail calls.
That's correct.
New jail calls from him to.
Last. From other pins.
Did I already revoke his privileges? So he just went around my order? Is that right, counsel?
Your Honor, based on what I've been informed by Ms. Zenda, that would appear to be the case. However, I have no direct information.
I'll take him on more. So you have information after I revoked his privileges that he was contacting the victim in this case, Ms. Zenda?
Yes, Your Honor.
All right, bonds revoked. I'll grant the adjournment to the 7th of May, 9 a.m. Thank you.
Thank you.
Court calls case People versus Ronald Bay.
Feltes to the people.
Assistant Public Defender Chelsea Vergils with and on behalf of Ronald Bay. Please state your name.
Ronald Bay Jr.
Thank you, sir.
Your Honor, we're asking for a preliminary exam in this case.
All right, discovery is complete.
Yes, Your Honor.
People have their witnesses available the 28th.
We'll try for that date, Your Honor.
All right, preliminary examination, April 28th, 2026, 9 a.m. That's before me. Okay, thank you.
Thank you, Your Honor.
Great.
Let's see you on the phone.
The court calls case People versus Terrence Smith.
Feltes to the people.
Assistant Public Defender Chelsea Vergils with and on behalf of Terrence Smith. Please state your.
Terrence Smith, thank you. All right, what are we doing?
Your Honor, regarding the probable cause conference, we need to ask to adjourn. I understand Mr. Smith wants a preliminary exam, but we haven't received any discovery yet.
You don't have the discovery to be able to go ahead
That's correct.
for advice. Is that coming anytime soon or do we know?
To it, and the media I just sent this morning. Or last night, maybe when I talked to Ms. Vergils, I can't remember. With the original discovery, it looks like it went over on the 10th. So I think they're trying to track that down.
Tracked it down. You want 2 weeks to do that? Because you got to go through it with him.
Yes, please.
All right. Probable cause conference then will be adjourned to April 30th, 2026, 9 a.m.
Have the date.
Bond continue.
Um,
Oh, go ahead.
like to address bond. Does the court,
Go ahead.
the bond violation today?
I would, but actually he's being held without bond at this point because of violation of the exclusion zone. So if you want to address it, we can address it.
Yeah, my understanding was that he was on a GPS tether on this case as well. If that is the case, we would ask to address bond at this time.
That he was on one? Yeah,
I
he
had,
was on one.
yes, I had a bit of confusion about that because this is just an R&O, not a DV, but Mrs. Feltis informed me this morning that there was a tether on this case too. I mean, I just don't want to postpone anything unnecessarily.
Well, I don't want to postpone anything unnecessarily, but there was an exclusion zone, from my understanding, that he entered. Right.
Your Honor, he would admit to entering the exclusion zone, and I would ask to address bond.
Go ahead.
You know, my understanding, based on my conversations with Mr. Smith,
That usually happens when somebody's about not to tell me the truth. Go ahead, Ms. Virginia.
Your Honor, so my understanding on what occurred in this case is that he did go in the exclusion zone. He admitted that. So he was with his cousin. He's having trouble finding work. His cousin offered him work. And he got in the car with his cousin, didn't know exactly where they were going. They entered the exclusion zone. His tether went off. They immediately left the exclusion zone. And Mr. Smith then called his tether agent. That's my understanding. I don't believe he was there for any prolonged period of time. And I understand he's being held on other cases. He hopes to be released on those cases. So I am asking the court for a personal bond.
I don't have any indication as to how long he was in there.
I was there.
I also don't have an indication in this that he called his agent.
I understand those details are not in the report. I haven't been able to get in touch with him, but I'm asking the court to take Mr. Smith's word for it. I don't believe that there was any contact, which is something that is included in the report.
Well, I might do that, except that usually if like the contacts like that occur or those kinds of things, that's specifically included in the report as to how proceed to take somebody into custody.
I don't believe he was taken into custody while he was in the exclusion zone. Yes, Mr. Smith?
Can I say something?
Yep.
423, he was taken into custody on the 13th.
I was taken in custody at home because I called my the GPS monitor dude, and then when I asked him, I was like, my tether just went off. My cousin had came and got me to help him move. And when I called him, he's like, he can't get no ping. And he said the police are outside. He's like, yeah.
I thought you were looking for work.
Yeah, I was looking for work. My cousin had offered me some money, but I couldn't. When I got there to the zone, when he pulled up, I'm like, cuz I can't be right here. So as soon as I pulled up, I had to leave. I couldn't even get the money. But I called the community corrections and I called my GPS monitor people. I called them.
Mr. Levitt, correct?
Yes, Brian Leverett, and I called the GPS monitor people and I admitted to being right there. I'll take full accountability, sir.
At this time, and until some of that can be verified, his bond is revoked because he entered the zone. I'm going to leave it at revoked at this point. If indeed get through to his GPS monitoring dude, then you can figure out from that person whether or not what he's saying, and I can get some verification of that. I'll certainly consider it.
I will work on that, Your Honor. Thank you.
Thank you.
I'll work.
Court calls the case People versus Kenyatta Johnson.
Special Feltus for the people.
Sorry. Yeah, Christina Saxon for Ms. Johnson on Zoom.
And she is. Oh, there she is. Ms. Johnson, can you state your name, please?
Kenyatta Johnson.
Thank you. All right, what are we?
Your Honor, we're asking for a preliminary exam date.
All right.
I just believe I have all discovery.
We'll have their witnesses available the 28th.
We can try for that date, Your Honor. I will note there is a co-defendant who's also on the record this morning, so if that matter gets set, I will request the same date.
Okay, and that co-defendant is in what block?
This block, Your Honor. It should be one of the next out.
Your Honor, if I may, Assistant Public Defender Jay Bellinger, on behalf of Michelle Schaffner, who I imagine will be called next. Your Honor, we will not be setting that matter for preliminary examination today, just to let the court know.
Okay. Are they true co-defendants?
They are.
They are. Okay. All right. What do you want to do?
I'm wondering if the adjournment's because she's getting new counsel, and if so, then I'm going to ask to adjourn.
Oh, okay.
Yes.
So
Okay.
your case, new counsel's coming in, Mr. Bellinger.
My client is seeking new counsel, Your Honor. She no longer wishes for representation from our office, and I'll make that record next.
Gotcha. Let me do this with your case, Johnson. I'm going to adjourn your case for a PC 30th.
Okay.
Thank you, Your Honor.
And then let's try to, if they need to be together, let's have them together. Okay. Okay, Ms. Johnson?
Okay.
Your Honor, I'll make a motion for Ms. Johnson to be allowed to travel out of state
Where's she want to go?
to Atlanta for her niece's graduation from May 20th through the 27th, which she will be flying.
Her niece is graduating?
Yes.
From where?
From, she goes to high school in Gwinnett County in Logan'sville, Georgia.
Oh, okay. So she's graduating from high school.
Not
Yes.
Spelman graduate yet.
What did you say?
Not Spelman graduate yet.
Why did you say Spelman?
Because it sounded right.
I was
think she
actually
looked at that
wondering.
school.
I was wondering only because my sister graduated from Spelman, so.
I'm sorry, seeds.
And I didn't like how they blew in white, so if she's going there, I was gonna let her go. No, I'm kidding. All right. What are the dates you need to travel, ma'am?
May 20th through May 27th. And I do have her flight information.
That's all right. All right. No objection. I will allow travel to Atlanta from the 20th through the 27th of May.
Thank you, Your Honor.
Thank you, Your Honor.
I will set this for the 30th, 9 a.m. Bond will continue. All right. Thank you. Thank you, Ms. Johnson.
Thank you. Thank you.
Courthouse case versus Michelle Schaffner.
Ashley Feltus for the people.
And Assistant Public Defender Jay Bellinger on behalf of Ms. Schaffner, who appears via Zoom. Ms. Schaffner, can you please state your name for the record and unmute, turn on your camera?
Michelle Schaffner.
All right. You're asking for an adjournment?
Your Honor, I would be
Yes,
asking.
Go ahead.
I would be asking for an adjournment to the 30th as well. I will make it clear for the record that there has been an offer made on this case. I would ask that that offer stay open for the time being. We were intending on setting for a preliminary examination today. However, Ms. Schaffner just informed me that she no longer wishes for our office to represent her, so she would be seeking new counsel on this. I don't believe she intends to retain.
You don't believe she intends to do what?
To retain. I don't believe she intends to retain.
Okay. Ms. Schaffner, is all of that correct?
Correct.
So are you you're intending on getting new counsel?
Yes, I just want a different person. Me and him, we don't see eye to eye. I feel.
That's usually because the client's not listening, but that's okay. Here's what I'm gonna do. I'll adjourn the probable cause conference to April 30th, 2026. 9 a.m. That's for you to seek counsel. That's the only adjournment you'll get for that purpose. Bond continued. Thank you.
Thank you, Your Honor.
Court calls case Weaver versus Thomas Sebastian. Court case.
On behalf of people.
With the Judge Porchel Feaster, Assistant Public Defender, on behalf of Mr. Vasher, who's approaching the podium. Mr. Vasher, please state your name.
Thomas Sebastian, correct.
Thank you, Judge. I think,
I'm sorry.
I think we're ready to try and move this matter forward. If we could set this matter for preliminary examination, these matters for preliminary.
All four of them?
Sure.
So discovery is complete. Will the people, this is available the 28th. Preliminary examination in person will be set April 28th, 2026, 9 a.m. before Judge Barr.
Thank you very much, Judge. He's not gonna give you a phone.
The bond continues.
He's not gonna give you a phone back. Well, thank you, Judge.
Thank you. Court calls case People versus Alan Fry.
Ashley Feltus for the people.
I'm sorry, Fry. Thank you.
Brian Bowling on behalf of Mr. Fife, Your Honor.
Good morning, Your Honor. Alan Fife.
All right.
Judge, we're asking for another adjournment. We're continuing to have some ongoing plea discussions. Kind of still waiting for management to kind of give us some direction. So,
We are requested, Your Honor.
All right. We'll adjourn it. Will May 7th give you guys enough time to?
I would hope so.
Probable cause conference, May 7th, 2026, 9 bond continue.
Thank you, Your Honor.
You're getting to be quite the star on TV, Your Honor.
Pardon?
You're getting to be quite the star on TV.
Is that right?
Yes, I saw you again yesterday.
I don't watch TV. No, I'm kidding.
Thanks.
Thank you for that, sir.
Thank you.
Court calls case of the People versus Jamie Gurney.
Ashley Feltus for the people.
Assistant Public Defender Chelsea deals with and on behalf of Jamie Gurney. Please state your name.
Jamie Gurney.
Thank you.
I have a green sheet here, Your Honor. We're asking to adjourn for a plea discussion. Is it possible to get 3 weeks, Your Honor?
May 7th. Will that work? That's 3 weeks.
Yes, please.
All right. May 7th, 2026, 9 a.m. Bond continued. Thank you, ma'am.
Your Honor.
Thank you, Your Honor.
Court calls case of the People versus Jason Haas.
Ashley Feltus for the people.
Here's mine. Okay, the blue pick. 3 hours now.
Thank you, and on behalf of Mr. Haas, please state your name.
John Honest.
All right, I have before me a plea form that indicates that the defendant is going to be pleading guilty to the charge of operating while intoxicated, second offense.
That is correct, Your Honor.
On a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding.
Yeah.
Yes, Your Honor.
May I have him sworn?
Right here. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the help you God.
I do.
State your name.
Jason John House.
Sir, it is this court's understanding you're going to plead guilty to the charge of operating while intoxicated, second offense. That is a misdemeanor. It is punishable by up to 1 year incarceration, 90 days community service, up to $1,000 fine plus court costs. Court can also order rehabilitative services that the court deems necessary. Court could also order your vehicle immobilized, could order you to pay the cost of prosecution, cost of any emergency governmental services. You understand all of that, sir?
Yes, Your Honor.
All right. Still wish to plead guilty?
Yes, Your Honor.
To that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
All right. You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any questions regarding any of those rights?
No, Your Honor.
Please look at paragraph 5 on that form. Those are your rights, which are part of a trial. You understand that with pleading guilty, you'll be giving up those rights as well as all the rights on that.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised anything? Bless you. Has anybody promised you anything other than what's been stated here today on the record to get you to
No, Your Honor.
plead? Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will,
Yes, Your Honor.
and because you believe that you're indeed guilty of this offense?
Yes, Your Honor.
April 28, 2025, at the location of South Maple Road in Ellsworth, in Pittsfield Township, Washington County, State of Michigan, you operating a motor vehicle.
Yes, Your Honor.
Prior to operating that motor vehicle, had you consumed intoxicating liquor as well as ingested controlled substances?
Yes, Your Honor.
What were those?
I think methamphetamine, the opiates that were on the list, I think that was from the ambulance.
Consumed fentanyl?
I think that was the ambulance.
Pardon?
I think that was the ambulance, like, yeah, because I don't really do that.
Your Honor, there was an accident and it's when he got in, they gave medicines. So he is acknowledging that he took
Methamphetamine,
Methamphetamine
and
time prior to.
yeah, and weed, and
Okay, had you smoked marijuana or ingested marijuana?
I used to, yeah. This is, yeah,
yes, at
Yeah.
that time, yes.
Okay, let me make sure I'm clear. Had you ingested or taken marijuana or THC prior to operating that motor vehicle?
yes, Your Honor.
All right. And had you also drank?
Yes, Your Honor.
All right.
That impair your ability to drive?
Why are you asking that? Were you,
It's in,
was there an accident?
yes, there you go.
Yeah, but it was more,
Yes.
yes,
You had an accident. The police came, correct?
yes,
They took you to the hospital
yes,
and there was a blood draw?
yes,
And the results of that blood draw showed the presence of methamphetamine, marijuana, and the alcohol. Is that correct?
yes, Your Honor.
Do you have any reason to dispute those blood test results?
Oh, Your Honor.
What happened with the accident? Do you recall?
It was kind of like a suicide attempt.
Okay. So you purposely crashed into something?
No, I was just driving recklessly, like, because I was angry and sad.
When was this?
Had you previously been convicted of operating while being intoxicated on or about March 15, 2019 in the 44th Circuit Court?
An OWI, is that what you were asking?
Yes,
Yes, Your Honor. I had one back in
2019.
Yes.
All right. Sir, if I accept your plea, I do have to advise you that between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not with recommendation or evaluation. You understand that, sir?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
Your Honor. I'm aware of none, Your Honor.
Have I complied with the court rule?
Or satisfied. The court has.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation as well as screening and assessment is ordered at 14A1 probation. Sentencing in this matter will be
13th at 9 a.m.
May 13th, 2026, 9 a.m. That is before me.
Your Honor, the probation department here, he can go there today, correct?
You can go right to the probation department, correct?
Thank you,
We
Your
give
Honor.
them instructions to meet with Bond Swartz. Bond will continue. Thank you. Court calls case of the People versus James Kearney Jr.
That's felt this for the people.
Assistant Public Defender Duffy Lieb on behalf of Mr. Kearney, who appears via Zoom.
He is not here.
Your Honor, I did speak to him yesterday. I do know that he's currently recovering from an injury.
What do you mean?
He was shot, Your Honor. I know that to be true.
Got it.
He's been in the hospital, I think, throughout some of this case, but I think he is now out of the hospital.
He is. I think he was just very recently released. So perhaps there was some issue with when the Zoom went out. I can call him if you could pass the case, Your Honor.
Why are you guys asking me? You know, I've only. Are you asking me to pass this case so you can call? All right, I'll pass. It's the same person I'm doing it for.
Thank you, Mr. James.
Court calls the case, People versus Frank Kyle.
People.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Kyle, who should be present in person.
Nope.
And Your Honor, unfortunately, Mr. Kyle also has a community correction site. I
Does.
think there's already a warrant. If not, I'd ask that one be issued.
And I did have a conversation with Mr. Kyle yesterday just to inform the court. I was anticipating that he would be here based on my conversation with him, so I have no, there's nothing to justify his absence.
All right, I actually issued a bond with no, or a warrant with no bond.
Thank you, Your Honor.
So I'm going to leave the bench warrant out standing.
Thank you.
Court calls case People versus Melvin Lilly.
Ashley Feltus for the people.
Brian Mulligan, we have from Mr.
Just state your name for the record, please, Melvin.
Melvin Lilly. Thank you.
Your Honor, we're asking this matter to be set for a preliminary examination. I believe all discovery complete.
And would people have their witnesses available the 28th?
Right for that date, Your Honor.
Preliminary examination in person, April 28th, 2026, 9 a.m. That is before for me. Bond will continue.
Right. Same place. Thank you, sir. Thank you, Judge.
Court calls case People versus Robert Lowry.
Feltus for the people.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Lowry, who appears via Zoom. Mr. Lowry, can you please state your name for the record?
Robert Lowry.
Thank you.
And Your Honor, I'm just seeking a couple weeks on this matter to get some information over to the prosecution.
All right. Probable cause conference without objection will be adjourned May 7th, 2026, 9 a.m.
Thank you very much.
Bond
Thank you, Your
continued.
Honor.
Thank you, sir.
Have a good day.
You too. Court calls case People versus Kenneth Mays.
Feltus for the people.
Morning.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Mr. Mays. Could you state your name, please, sir?
Yes, first name is Kenneth, last name Mays.
All right, what are we doing?
Your Honor, we are requesting an adjournment. We requested some additional discovery and are asking for a short adjournment so that we can go over that with our client.
You see his progress report
No, Your Honor.
on the 10th. Tested positive for cocaine, amphetamines, and THC. And then 5 days later, he's testing for the amphetamine and THC.
Could we have a few moments to discuss the report, please?
Well. You're going to be requesting an adjournment?
I'm just asking to pass it for a few moments right now.
He's not to leave the courtroom. Take your hand out of your pocket.
Yes, sir. No problem, guys.
All right, I'll let you talk, Ms. Gaines.
Thank you.
Pass it briefly. Court calls case People versus Ryan Miller.
Joy Gaines, Senior Assistant Public Defender. Your Honor, I have called Mr. Miller's name in the courtroom without any response, and we were not able to get in touch with him prior to today's hearing. I think he might possibly be at the Delonis Center. I would ask for a short adjournment to try to get in touch with him.
Bench warrant will issue, found 10,000. That warrant will issue immediately. Court calls case of the people versus Matthew Forson, AKA Esther Murphy.
Assistant Public Defender Chelsea Vergils on behalf of Esther Murphy, formerly Matthew Morrison. Your Honor, I haven't had contact with this client.
Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of 10,000 cash surety. That warrant will issue immediately. Court does call the case of the people versus Dion Nelson.
Ready, Judge. Court shall please the Assistant Public Defender on behalf of, but not with, Mr. Dion Nelson. Your Honor, we've called and tried to find Mr. Nelson. We do not know why he is not present. For the record, we request an adjournment.
Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $10,000 cash.
Thank you, Judge.
Thank you. Court calls case people versus Deshaw Patterson.
Calls for the people.
Let's see.
On behalf of Ms. Patterson, please state your name for the record.
Deshaya Patterson.
Okay.
Your Honor, we were unable to reach Ms. Patterson prior to today's hearing. We're asking for Ms. Megan in order to get some additional, have a chance to talk to her about her case.
That objection, probable cause conference, May 7th, 2020. 9 a.m. Bond continue. Thank you. Thank you, man. Court calls case people versus Leo Stringa.
Ashley calls for the people.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Stringer, Your Honor. I submitted some documentation that Mr. Stringer was released from the jail and taken directly to a treatment facility. And not, I'm requesting an adjournment, Judge.
It's a 20 up to a maximum of 30 days. And this letter's the 15. Okay, so what I'll do is I'll grant the adjournment. I'll adjourn it to May 21st.
Thank you.
2026, 9 a.m. Bond continued. Court recalls case viewers, Deborah Collette.
Calls for the people.
We have, have you let all the people in?
Assistant Public Defender Chelsea Vergils with and on behalf of Deborah Collette, who appears via Zoom. Ms. Collette, please press *6 to unmute. And state your name once you're unmuted.
Ms. Collette? Ms. Collette, could you hit *6 on your phone? We were sure that was her.
Yes.
Ms. Collette? You're referring her for sobriety court.
Yes, Your Honor, I apologize. I know she tried for a very long time to get logged on with video and wasn't able to do so.
And she was, okay, I get it. What I'll do is I'll adjourn probable cause to May 7th, 2026. I think that's her. And we can't send her a message, so maybe somebody can try to reach out to her. But I'll just adjourn it now.
Thank you, Your Honor. And just for the record, I did see prior to the name change, it was her phone number that I spoke to her on today that appeared on the scene.
Got it. Thank you.
Thank you, Your Honor.
Court calls the case, People versus Gregory Jones, recall.
Michael Gabbard, defender on behalf of Your Honor. Thank you for calling. Better. Mr. Jones, after some technical difficulties.
Yes. Mr. Jones, can you state your name, please, sir?
Yes, Gregory Jones.
Thank you.
Your Honor, we'd ask to set this matter for exam.
Discovery is complete.
Yes, Judge, to the best of my knowledge.
Either witness available the 28th. Preliminary examination in person. April 28th, 2026, 9 a.m. That's before Judge Barr.
Thank you, Judge.
Thank you, Bond. Continue. Thank you. Thank you, sir.
Thank you.
Court recalls case People versus James Kearney.
Feltus for the people.
Assistant Public Defender Davi, leave form Mr. Kearney. Unfortunately, I was not able to reach Mr. Kearney, although I do appreciate the court passing the matter.
You need to thank Ms. Virgil.
Thank you, Mr. Virgil.
Because I wouldn't have done it. Bench warrant will issue in this case 10,000 cash surety. That warrant will issue immediately.
Thank you, Honor.
Thank you. And recall the case of the People versus Kenneth Mays.
Ashley Feltus for the people. Union Assistant Public Defender. And on behalf of this union.
Thank you for those moments. For those, let me talk about the report. Your Honor, in speaking to Mr. Mays, he acknowledges that the first test result of April 10th was immediately after he was arrested and released from the Washtenaw County Jail. And he does acknowledge having used a substantial amount of substances prior to his arrest. And his testing was within 24 hours of using those substances. And so we'd like for Your Honor to focus on the next date, which clearly shows that he has not continued to use cocaine. There is not a positive for cocaine. He is working on getting the marijuana out of his system. He indicates that he has been a heavy marijuana user. We are not clear about the amphetamines, but he is very open to going to substance use treatment. He recently obtained employment and he's currently working. If the court would give him the opportunity to try to maintain his employment and go to some sort of intensive outpatient treatment, he would be very, very much appreciative of that and is willing to test if the court wants more frequently. Is that fine with you?
Absolutely. So he's admitting to the violation as to at least the 5th.
He is indicating that there's definitely would still be some marijuana in his system based on
What about the amphetamines?
we have no explanation for the end.
So does he want a hearing on that, or what does he want to do?
Would you like a hearing? Would you like a hearing on that? That was something more cool.
Your Honor, I've been fighting hard to put things back together and just brought an opportunity for me to change things around in my life. To successfully gain employment. I had previously experienced a lot in life, as far as life-changing situations, finally get the direction to put things in a better direction. Am I wrong for doing the things that I have done? Absolutely, Your Honor. It's just been a hard fight, last few years. To say some life-changing situations, to where life just wasn't the best. I want to kind of put everything out there, but I fought self-defense murder, and I was able to overcome it. And it has been, just mentally just a challenge. And just as I started to, want things to come better for myself, I just looked at this opportunity of me clearing up things that I've done in the past to move forward. Am I right? Did I make the right decisions? Absolutely, I did not. I accept all accountability for my actions. I just believe that me being incarcerated right now just sets me back further from going into a better, positive direction.
So with that, it doesn't sound, he is not looking to adjudicate the issue. And he acknowledges that he has a substance use problem and is just asking for another opportunity.
I have been fighting.
Whatever, they'll adjourn this matter out 1 week. We're gonna have to try to figure out something that April 23rd, 2026, 9 a.m. If he wishes the hearing, let the court know and we'll set it at the time, but at this point, his defendant remanded. Well,
Yes.
that's it for that block. Get a break. All right. Court consideration. Court does call the case of the people versus Raymond. Fair.
Good afternoon, Your Honor. Chris Easto appearing on behalf and with Raymond Paranello. Mr. Paranello, would you state your name for the record?
Raymond Scott Paranello.
Thank you. It's a waiver.
It is a waiver, Your Honor.
So you're waiving your right to a preliminary examination?
Yes, Judge.
To understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense is alleged or committed and that you committed.
Yes, I do, Your Honor.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on count 1 with 2 files.
Your Honor, we'd waive a formal reading. We'd waive presentment of the information at this time, and my client would stand mute.
Defendant having waived formal reading, standing mute to both counts. Court will enter a not guilty plea. Pretrial will be set for
1:30 with Judge Conlon.
June 10th, 2026, 1:30, Judge Conlon.
Your Honor, if I could address mine quickly.
No. I don't know why you do this. Go. Fine, Husto, go ahead.
Thank you, Your Honor. I know he's out and
Okay, I know. I do what I can. And now
because this was a blood test case, my client is currently on a Scram Tether, no violations or anything. He was arrested at airport. Him and his wife own a travel and tour company. And because he wasn't aware that the warrant came out because the blood test took a while to come back. They're at the airport. He gets arrested at the airport. When he was arraigned, because he was at the airport, they told him he had to turn in his passport.
Wow.
He's an American citizen. no issues with that. So what my bond.
Not that that matters.
It's
I'm sorry.
it's so true.
I am
Not matter.
comments. Go ahead.
Good commentary, Governor. So what he'd like to ask the court to amend his bond to travel for him and his wife's business. He has no problem with taking the I told him TSA may have a say if the judge grants that amendment, but TSA may not let him travel with that tether. And if so, then he can't travel. But he would request that Chelsea PD turn back his passport and allow him to travel to the Caribbean to do tour. They do site visits, him and his wife's company.
Okay, so all right. As I'm hearing you, there are two issues. One, he needs his passport back. Right.
Correct.
And the other would be the ability to travel for business.
Correct.
All right. Do people have a position?
Yeah, as long as the Scram tether continues, I have no objection.
Let me ask this. Sometimes we have problems, sometimes we don't with the Scram tether. Was the Scram tether a problem? Well, he hasn't he hasn't done it.
Correct.
Defendant's bond will continue. I will permit the defendant to travel for business purposes. So that, sir, that you know that you'll have to provide proof if questioned by the court regarding.
Okay.
I also will specifically order you to put that on there that Chelsea, you said Chelsea PD has it?
Yeah, and I'll reach out to Detective Gilbert. They told him that they were going to send it here, but I don't believe they have. I know that
here,
his passport, but I know that sounded strange to me when he told me that. So I can follow.
Usually hold passports. It's usually held by the police agency. So if they tried to give it to us, we would give it back to the police agency. All right. So let's do this, and I'll order it this way. If the Chelsea Police Department is still in possession of his passport, I'll order that they return that to the.
All right, thank you. Your Honor.
Appreciate it. Thank you. Thank you.
I'm representing information. I will get it.
All right. Court calls case People versus Jennifer McCready.
Ashley Feltus for the people.
Good afternoon, Your Honor. If you can hear me, this is Matthew Mansour on behalf of Miss Jennifer McCready, who appears via Zoom today. Jennifer, can you please unmute, put your camera on, and state your name for the judge?
Yeah. There we go. Sorry. This is Jennifer McCready.
Okay, there she is. Yeah.
This is Jennifer McCready.
I'm sorry. Yes. Okay, correct. Well, yes, ma'am. Thank you. All right, what are we doing?
Thank you, Your Honor. Today is the date and time set for a probable cause conference. I believe discovery is complete. We would like to set this matter for preliminary examination, please.
We'll have the witnesses available the 28th.
We'll track that date, Your Honor. Thank you.
Preliminary examination in person will be set April 28th, 2026, 9 a.m. before me.
Thank you, Your Honor.
Bond will continue. Thank you. Court calls case of the People versus Demetrius Caldwell.
Ashley Feltus for the people.
And good afternoon, Your Honor. Sydney Rushing appearing on behalf of Mr. Caldwell. Your Honor, I believe Mr. Caldwell is still in custody.
In custody where? You told me you were going to be here today.
No, I didn't.
Yes, you did.
When? When did I say that, Judge? If I did, I apologize.
You told me that.
Judge, I don't recall saying that. Usually I'm there if I'm gonna, if I say. I'm-
Thanks for sticking up for me, Ann. Wow.
Judge, I'm not, I believe he's in the Washington County Jail. We were waiting, and a competency report. I just received the report this morning in the mail. It was in my mailbox this morning. So I'm just seeking a 1 week adjournment just so I can talk about the report with him and then the court can enter it.
That's fine. Is he in our jail?
This morning, I think we had this conversation. He wasn't on. XGL shows him having posted bond.
So XDL shows him posting.
Okay, Judge, I wasn't aware that he had posted bond and his guardian, I hadn't heard anything from his guardian stating that they had posted it or anything. That I
So you
thought,
want me just to put it out a week?
please, Judge, that'd be greatly appreciated.
All right, are you gonna be here or no?
Judge, depends, if I have a trial next week or not. No, I'll come in person. I'll come see you next week, Judge.
So no, it's okay. I don't mind like being second fiddle.
It's not second, Judge, not second at all.
No, it is, and I'm hurt. What's sweet? April 23rd, 2026, 9 a.m.
Thank you, Judge. I'll see you next week on that one.
Oh, don't promise me things you won't keep. Bond continue. All right, thank you, Ms. Rush. Court calls the case People versus Rachel Pichette.
Ashley Feltus for the people.
And good afternoon, Your Honor. Sydney Rushing, appearing on behalf of Ms. Pichette. Ms. Pichette, can you state your name for the record, please?
Rachel Pichette.
Thank you. Your Honor, we are just seeking a very brief adjournment on Ms. Pichette's matter. The outstanding misdemeanor matter that we were working with resolved yesterday. I do believe we have a resolution in this, so paperwork just needs to be submitted. And I think we're just waiting to see if there's any digital. I have paper. It's an older case, so I'm not sure if there's digital or not, but I believe we have a resolution.
All right. So if I put it out a week, you'll have the paperwork in to do whatever you need to do, or no?
Yes, Judge.
All right. Probable cause conference will be set for April 23rd, 2026, 9 a.m. Bond continued.
Thank you so much, Judge. Have a great day to you and your wonderful staff.
You do the same.
Thank you. Thank you.
Court calls the case People versus Rebecca Dooley.
Ashley Feltus for the people.
Good afternoon, Joe Simon on behalf of Ms. Dooley. Ms. Dooley, state your name.
Rebecca Dooley.
Your Honor, this is the case that Mr. Cook and I approached you about a couple of weeks ago. The people, I believe, are going to move to remand the matter on an OWI second to your Honor's docket for a date for pretrial after April 18th, as the court may remember why.
All right. So that's what's happening today.
That would be my motion to remand it on that added count of OWI the second. I do not have an amended complaint. I apologize, Your Honor, but I can give the court one.
Okay. So here's the way I'll do it. Well, so the other two are felonies right now.
Right.
They're going down on on count 2 or no?
I believe what Mr. Cook had said was he was gonna, we can, because we can pre-try that, Your Honor. How's that?
We ran out of count 2 with an added count 3 of OWI second.
All right.
It's missing count 1 in this time.
So what I'll do is I'll continue as plea to count 2, wait for presentation of the complaint as to a count 3 of OWI second. We'll dismiss count 1. And the pretrial date needed to be after the 18th, was it?
Correct.
Of April? Or
That's correct.
okay. May 6th, will that work?
I'll make it work. Thank you.
May 6th, 2026, 9 a.m. Before me. Bond will continue.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Both. Court calls the case People versus M.I.A.
Joe Simon on behalf of Mr. Issa. State your name when you get up here, Ahmed.
Ahmed Issa. Thank you, sir.
Your Honor, this matter we're requesting for a preliminary examination, please.
All discoveries complete.
Yes.
Will have the witnesses available to 28.
Your Honor, you know,
no, go ahead, sorry.
You know, that's a terrible day for me, but I'll make, I'll make.
I don't care.
I want
my work. That's okay. No, go.
Expediency is important for him for a couple of reasons. Let's just keep it there. Let's do the.
Will that work?
I'll make it happen.
You will? All right.
No,
you want a different date, Mr. Simon? I mean,
I did, but the next available is the 5th. My client's going on his honeymoon on May 6th, which we're going to ask for permission to leave before. But we hope
it's not doing it.
We hope
you're gonna flew right past it.
We hope this might reach a dispositive resolution on the 28th. That's why I think it's better to do it on the 28th.
Honeymoon? Oh, that's all right. But preliminary examination will be set April 28, 2026 at 9 a.m. before me.
Thank you.
And did you want to ask to go on that now or?
Yes, I think it's only appropriate. He's not actually going to a very elaborate destination, but he wants to leave the state from May 6th to May 18th. Yes.
Well, now we got to know where he's going.
We're going to Florida on May 6th for my wife's graduation from UCF, and then from Florida, Orlando.
Central Florida?
Yes.
I hate them. They're the nice. Don't they? Okay, go ahead.
And on the 10th of May, we will go to
where?
Antigua, an island.
Oh, yeah. Oh, I know. Really?
Oh, okay.
I just didn't hear.
So the 18th.
All right. I will. So the dates are
May 6th to May 18th.
So I will just indicate that the defendant may travel out of the state of Michigan from December 6th through the 18th. Those include your travel days, sir?
Mhm.
Okay. All right.
Thank you, Your Honor.
You're welcome.
You can go home. You can wait if you want.
Okay.
Thank you, Your Honor.
Thank you. I have before me a plea sheet that indicates that the defendant will be pleading to an added count 3 of operating while intoxicated second offense, a 1-year offense. Upon a successful at counts 1 and 2. Best defendant is also to enter into and participate in the court sobriety court program. That's the court's full understanding of.
That's completely correct, Your Honor.
That's correct, Your Honor.
May I have him sworn?
Do you solemnly swear in front of the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Name.
John Lenz.
Sir, it is this court's understanding. We're going to be pleading guilty to the charge of operating while intoxicated second. That is
Yes, Your Honor.
That is a misdemeanor punishable by up to 1 year incarceration, communities, and a $1,000 fine plus court costs. The court could order community service and any rehabilitative programs the court deems necessary. Could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir?
Yes, Your Honor.
All right. Sir, you also understand that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Freshour in the 18A3 District Court. Understand that?
Yes, Your Honor.
All right. Still wish to plead guilty?
Yes, Your Honor.
To that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
All right. Signed in advice form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal upright.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily?
Yes, Your Honor.
Of your own free will?
Yes, Your Honor.
And because you believe that you're guilty of this offense?
Yes, Your Honor.
December 18, 2025, at the location of Riker Road near Stillwater Drive in Dexter Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes, Your Honor.
What'd you have and how much?
I had roughly 3 to 4 shots and about 10 or 11 beers.
Were you stopped by the police or was there an accident?
I was stopped by the police.
Okay, why'd they stop you?
I was asleep at the wheel.
Were you ultimately arrested?
Yes, Your Honor.
You were taken to the hospital for a blood draw?
Yes, Your Honor.
And what was the results of the blood draw?
0.232.
You don't have any reason to dispute those test results, do you, sir?
No, Your Honor.
All right. And had you previously been convicted of operating while intoxicated on or about January 12th, 2018 in a Kentucky court and or of operating while intoxicated on or about June 29th, 2021, also in a court in Kentucky?
Yes, Your Honor.
Sir, I do have to apprise you that if you commit misconduct between the time that I accept your plea and the time of your sentencing, misconduct is defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes, Your Honor.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court?
You are satisfied.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed. I'll indicate a pre-sentence investigation is ordered. However, most of that's been done since he's going to be sentenced into sobriety court. Sentencing in this matter will be April 23rd. And 26. What time was that?
9:30.
And 9:30.
Yes.
9:30 before Judge Fresh Hour. Bond will continue.
Thank you, Your Honor. Can we outside?
When you get your when next? I think Mr. Simon's got a few more. Court does call the case of the people versus those
Exactly. Your Honor, Joe Simon on behalf of Mr. Titterington, who is almost to the podium. State your name, Judge.
Joseph Titterington.
taking an adjournment.
Correct, Your Honor.
Will the 30th work for you? You want the 7th?
I think the 30th should work just fine, Your Honor.
Probable cause conference, April 30th, 2026, 9 a.m. Bond continued.
Thank you. You can go home.
Court calls case People versus Matthew Visconti.
And Your Honor, Joe Simon on behalf of Mr. Visconti. State your name,
Matthew Visconti.
What are we doing?
I should have a green sheet there, Your Honor. I'm sorry.
Yeah, I do.
Okay.
Probable cause conference, April 30th,
Thank you, Your Honor.
2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
That's for the Simon show.
I believe that is.
That is.
Your Honor.
Mr. Simon, say something. Court does call the case of the people of the state of Michigan versus Adam John Allen.
Good afternoon, Your Honor. Deborah Schlossel on behalf of the defendant, Mr. Adam Allen. Mr. Allen, please state your name.
Adam John Allen. Thank you.
Your Honor, at this time, pursuant to plea negotiations, we are in the process of trying to get Mr. Allen into a specific sobriety court that is taking some time. We are asking for an adjournment out for some time so that we can get that resolved.
May 7th.
That works for me, Your Honor.
May 7th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Thank you. Court does call the case of People versus Ashley Albert.
People.
Good afternoon, Your Honor.
Good afternoon.
Christina Costantino, appearing with and on behalf of Ashley Elber. Ms. Elber, can you please state your name for the record?
Ashley Elber.
Your Honor, we're seeking an adjournment of the PCC today. There are still some negotiations we need to have specifically concerning the amount of requested restitution. And so we would be asking for an adjournment.
May 7th, does that work?
Thank you, Your Honor.
2026, 9 a.m. Bond continued.
Very much.
Thank
Judge.
Thank you. Court does call the case of the people versus John Manning.
Calls for people.
Christina Costantino appearing on behalf of Mr. Manning. Unfortunately, Judge, I am not appearing with Mr. Manning. I do not know his whereabouts at this time. I have made attempts to contact him and have not been able to locate him. Doesn't appear he's in the hallway or the courtroom today.
That's probably because of the bond violation.
Yes, Your Honor, I'm aware that there's a community corrections warrant already. I'd ask that be continued.
So I'm just going to leave the bench warrant outstanding.
Thank you, Your Honor.
Thank you very much.
Thank you. Yeah, for you.
No, I'm not. You wouldn't get out that easy.
Court calls the case people versus Michael Smith.
Costantino appearing with and on behalf of Mr. Smith. Mr. Smith, can you please unmute, turn your video on, and state your name for the court?
Michael Smith.
All right. You're requesting an adjournment in this case also.
Yes, Your Honor, for further negotiations.
I'll adjourn the matter out till May 7th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you very much, Judge. Now I'm done. You have a good rest of.
Take care. All right, take that one. Court's gonna have to stand off, take a brief recess, right? Court stands in recess. Court calls the case of the people versus Cheetos.
Your Honor, good morning. The Office of the Public Defender does not believe a conflict exists between this honorable court and the Office of Public Defender. But if one were to arise, we would waive any claim that a conflict exists.
Your Honor, people do not believe that there is any conflict present. Following the event that conflict were to arise, the people would similarly waive any such.
Court also does not believe there's a conflict either in the Michigan court rules or the cases decided thereafter. To the extent a conflict does exist, given the waivers, the court will consent to hear plaintiffs. All right. Mr. Brown, we have a bond violation.
Yes, Your Honor, I've shared it with my client. He will admit that he tested late on the dates contained in the report from April 15th, authored by Community Corrections Supervising Agent Charles Mormon. I can give the court some background.
Go ahead.
Present here with his mother, who took her time out of her day to come see about her son. What was going on with him? He was working at, I believe it was Burger King on Stadium, Taco Bell on Stadium, and he worked 4 night shifts and 2 morning shifts, and his biological clock was thrown off by some of those hours. So for example, he'd get off work 3 or 4 in the morning, and then he was supposed to test between 4 a.m. and 7 a.m. and fall asleep. But he'd wake up and then he'd test, and his tests were negative for any controlled substance.
Why did he test it? I mean, there's a 3-hour window.
You sleep after working a shift at kid, 24 years old, Your Honor.
But we had sent to him, I mean, there were times before this at the problem, and we had sent an order to comply to him back on March 9th, so not taking any action. And then he was good for about 10 days. And then proceeded to have 1, 2, 3, 4, 5, 6, 7, 8, 9. It's test.
Missed, but they were compliant. No alcohol. If we're on page 2.
I understand there's no alcohol, but I could consider these violations. He's supposed to test in that time window.
And I've impressed that upon him, Your Honor. That's why he's here. Also, he he's now left Taco Bell and he's at doing landscaping, and he's advised his agent. So they adjusted or tried to accommodate his work schedule landscaping now. And I have his works.
How is that gonna work? Landscape. That could be even more problematic.
I talked to him about that, but he thinks that he's worked it out with his agent so that they now have a plan so that he's going to comply and test during the windows that you've ordered.
Anything from the people?
The court indicated the court is quite clear, even on the April retrial, there was not to be any more late tests, and unless we've gotten us late tests, I think the best way forward is Scram Tether. That way, there can't be any late tests, and we continue monitoring the defendant.
In his defense, Your Honor, he was seen by Mr. Statman and got his assessment on April 17th. So we are trying to move forward with the case. We're not dragging our feet, and I'm not changing the subject, but he's got a new job and he's trying to do better. And he's got his mama here in court today. Ma'am?
Oh, I see her. All right.
Did I miss anything? Okay.
Only there was some time that he wasn't able to change the testing schedule when he switched jobs and switched schedule. I think that was an issue.
And ma'am, for the record, what's your name? Sarah Ladd.
Mother's Day is coming, Judge.
What am I supposed to do with that?
Mother's Day is coming. I mean, it says a lot. She's standing up for it.
I get that, but I mean, I've got 14 missed tests.
Yes, Your Honor, but no alcohol. She'll tell you he's not drinking.
Young man, when you got the order telling you to comply and no more late tests, and when I told you at court no more late tests, what were you thinking?
To just try and get them on time. Try to not go for any more late ones, but sometimes I just lose track of time when I'm at work. Most of these have only occurred when I'm physically at work.
Anyway, I shouldn't just throw you in jail. You don't listen to the court's order. That's 2 orders you haven't listened to. You have the first order telling you to test, and then I sent you another order telling you to comply.
Well, I don't think I should be put in jail because I'm besides being late, I'm complying with everything else and doing exactly what I need to be doing. Not touching drinks, just working and doing what I need to do.
What about your association? You still hanging out with the same people you're drinking with?
No.
What I'm gonna do is, defendant having admitted to the violations, I'm not gonna incarcerate you at this time yet. But you're gonna go over to community corrections, you get placed on the Scram Tether. Any types of violations such as not being charged, not properly downloading, all of those things. If you don't follow that to a T, you're going. Am I understood? I didn't hear you. Thank you.
Yeah.
Do you have the unit with you?
Yeah.
You take that over and they'll fit you with the Scram Tether.
Okay.
Court does call the case to reverse concurrence. Oh,
It's already.
it's already.
Okay.
Yeah, this was a bond violation.
Bond violation. All right.
Court does call the case, first concurrence.
That is on behalf of the people, Your Honor.
Morning, Your Honor. Richard Blifford on behalf of the defendant. Ernest is here in the courtroom with me.
Your Honor, today's date and time for an emergency bond violation hearing. At this time, the defendant is going to acknowledge the allegations that are set forth in the complaint.
Bond violation.
Bond violation, correct.
Okay. Anything from the people?
Your Honor, I'll just rely on our previous motion. I do want to say, I did mention that there could be a potential for future charges. I do need to get a little bit of further investigation done before I make a final decision on that for both defendant and defendant's mother. They were both submitted on by Ann Arbor Police.
Who was?
Defendant and defendant's mother.
All right. Okay. Anything you want to say?
There are actually quite a bit I want to say, Your Honor. Defendant is the parent, is married to the victim in this case. There's a highly toxic and dysfunctional relationship with victim. The victim sought a PPO. There was never any allegation that there was striking, hitting, assaultive behavior in the PPO. There's more threatening behavior and things of that nature, but not like I've been punched or I've been hit or anything like that. In any event, the PPO was put into place earlier in the winter. The PPO obviously was at the choice of the victim. I'm just going to lay it out for you, Your Honor, and maybe in a way that's not helpful to my client, but I'm just going to lay it out for you. These people have been in non-stop communication with each other since the day the PPO was granted. Hundreds and hundreds of text messages. I just looked at my client's cell phone log this morning before in the hallway before I came in here. Hundreds of text messages, including, Your Honor, more than 25 text messages yesterday. The parents have a child together. The child's birthday, his first birthday was on April 12th. The parents went to church together on April 12th for a birthday party for the child. They visited with the fire department and took the child on a ride in the fire truck together recently. The victim, I read through every one of these texts, and as an officer of the court, I could tell you that there is not a scintilla of evidence that indicates that the victim is scared of the defendant. The victim is asking the defendant to come and be part of her life. The defendant has Venmo'd the victim thousands of dollars since the inception of the PPO. How does he Venmo her? She calls him and says that it's money and he Venmos her money. The victim has shown up at the defendant's house. Defendant has been at the victim's house. It's a highly dysfunctional relationship. Some of the texts, Your Honor, that the victim has given I read this morning, some of the texts, the victim is advising the defendant on how to beat this case, on what strategies he needs to be using to beat this felony case against him. And so I'm making some admissions to the court that maybe under some circumstances would be against the best interests of my client, but I've been in front of you, Your Honor. I know you're a straight guy, and I think the court would rather hear this than some nonsense. That's been the relationship that's going on here. The defendant is 31 years old, Your Honor. He's a honorably discharged member of the United States Army, served in the airborne, served in Ukraine, served on the border of Syria. He receives an 80% disability payment through the Veterans Administration for some lower back issues as a result of parachuting. He has been enrolled at Washington County Community College, and on May 6th,
He's supposed to receive his associate's degree in transportation technology. So he's been involved in a 2-year program. He's supposed to graduate from that program in the next 2 weeks, Your Honor. He has final exams coming up in the next few days. Court can see his parents are here with him. They share with me, and the victim and the defendant shares with me, that there is some counseling that he can get through the VA that would probably be appropriate. As an attorney, and I know you're an attorney, it's frustrating to me that the defendant has conducted himself in this way. I've shared my frustration with him about this. It's just very frustrating that I can't impress upon him that, or I haven't been able to as of yet, that I don't care if she shows up at your house. If she shows up at your house, you run in the house and lock the door. That's what you do. And that's how you handle it. And so there's been some monumental bad judgment here. In regards to this allegation of an ear tag being put in her car, the defendant says that took place at his house with the victim participating in this. So,
excuse me, that he and her did it, that they did it together?
He said that she came to his house unannounced in Ann Arbor, his parents' house where he lives. They discussed putting an ear tag in the car so he would know where her and his child is. And she said that would be a good idea. And the ear tag was placed in the car. And
that's true. Then why does she have concerns when it alerts her phone?
Because it's a highly toxic relationship, Your Honor. The parents are trying to evict the parents are in the process of evicting the victim from their condominium, where the former marital home. The parents are the owner of that home. They're in the process of evicting it. It's a cluster of incredible proportions that are happening here. The amount of legal fees in this case are eye-watering, Your Honor. And I think that I come here today asking that the defendant be given another chance. And I can't promise the court that he's going to be able to control himself to not communicate with this person. I think that this brings it to a level of seriousness that we haven't seen up until now. But I think that he deserves another chance. There's no allegation of physical.
Well, and maybe counsel, and I get that they've got a child together and that there might be some conduct, although there shouldn't be.
Hundreds and hundreds.
Right. But the problem is he's the one under the court's jurisdiction. And I know you know this.
And
he's the one that cannot have that conduct.
And I've told him that. His parents have told him that.
But what I don't get is I don't understand this air tag. If they're having so much contact, why do I need an air tag?
Well, I mean, I could just tell you anecdotally, on my phone, I can see where my wife is at all times, and so
I can do that without an air tag.
Yeah.
All she would have to do is share her location with him, and he would know.
Your Honor, all I can tell you is I'm seeing texts as early as this morning at 9 o'clock, at 8 o'clock this morning, texts from the victim saying, I'm going to the prosecutor's office because this is all a big misunderstanding. I'm not making that up. That's the text I see from the victim at 8 o'clock this morning. Okay. I saw the same text from the victim 3 times yesterday. She texts him that this is a terrible misunderstanding. And so the defendant is here. He's executed, he's demonstrated monumental bad judgment. We're here falling on our sword. We're not here trying to say that this didn't happen. I told my client, what are you gonna do? You're gonna come tell the judge you didn't do this? You're not gonna lie in court. And so We can't do that. That's not an option to come to court and deny this. That's just not an option. It's not an option for me as an attorney. It's not an option for the defendant. And so there's just bad judgment here. I'm hoping the court could give him the proverbial second chance. I'm hoping that you could impress upon him the seriousness of this. But I'm asking you not to take him into custody, Your Honor. I just don't think it rises to that level.
That's, counsel, let me just say this. I hear what you're saying about the contact, and that shouldn't even be happening, and I'm sure you're after about that. It rises to a different level when I'm tracking your whereabouts. That's my problem.
The defendant tells me that this was done cooperatively between the parties. And
then I heard you the first time regarding that, and I don't believe it. The reason I don't believe it is because he obviously hasn't been following the court's orders, but also that the whole tenor of the police report, which I'm sure you got a copy of,
I did,
doesn't indicate that this is anything cooperative on her part.
I know, but Your Honor, this is also somebody who went and sought a stalking charge and then went and contacted the person saying, this is the police understanding here. I never meant to see you charged like this. I mean, so you have a very frenetic victim here who is, on what day of the week, it's a toxic relationship. These people do not do a good job communicating with each other. So if for chance, she asks for a Venmo and it doesn't go through, guess what? She's off to the police department. I mean, that's the nature of this relationship. And that's something that needs to be resolved via the divorce. But I mean, this is an insane relationship here. And from what I gather, and I'm not a testifier, from what I gather, it doesn't rise to the level of striking each other or hitting each other in the face or that type of thing, But as far as, daggers out and just sort of crazy conduct, these people are involved in a spiral of crazy conduct with each other. They're both part of this crazy conduct, both of them. But you're right, Your Honor, the defendant is the one who's here in court. The victim is not in court. She's not on the court doesn't have jurisdiction over her conduct as to whether she shows up at his house. And so it's just been bad judgment. It's terrible judgment. And, that's, it's funny because, I thought long and hard about this weekend. What am I going to say to you? I really, belabored in my mind, what am I going to say to you? And this is what I'm going to say to you. And I think he deserves another chance. I do believe he can fly straight. And that's our prayer to the court, Your Honor.
So
I did also want to note in the court that our victim advocate did speak with the victim today, and I also spoke to the hallway. That's where I was before this, and I didn't have any mention of any of that, including the cooperative air tag on her part. I told her she can leave before this because she was not testifying. She wanted to leave. She didn't want to be present today in the courtroom, but she did not mention any of that. And I have not seen any of these texts either.
But she did not indicate that this was somehow cooperative or somehow
No, Your Honor.
that the police report itself was some type of misunderstanding.
No.
Did she indicate to you that the entirety of the case was a misunderstanding?
No, she informed me that, and I was just throwing, she wanted him to get out. And she was concerned about his parents and what was coming with that. So she just had concerns with what was going on.
There's a highly conflictual relationship between parents and the victim as well. It's off the charts, Your Honor. Mainly revolving an eviction.
And How old's the child?
Child just turned 1 year old on April 12th. That's when.
This is the part that's phenomenal to me. I've got the parents at each other in some way. Well, I think somebody may have arrived. Sure. I've got the circumstance that the parents are at each other, the parents of the child are at each other, defendant, his wife are at each other. There's a divorce going on. There's then this stalking case going on. There's then going to be, thank goodness, the premises, I think, are in Ann Arbor, so it's not my jurisdiction. There's then going to be an eviction that's going on, which makes no sense to me. Everybody keeps raising this to whatever level. The other concern that I have is, and counsel, I get what you're saying to me. Trust me, I do.
Thank you, Your Honor.
And I get the notion of periodically through the weekend after I'd seen the motion, I'm trying to figure out what was he gonna tell me after I went through and read the police report and everything. And I don't want to necessarily escalate it, but I'm having a difficult time believing, with everybody operating with iPhones, that the purpose of that tag was as you said it was. She's here. If you want me to put her under oath, and then I'll figure it out that way. But if I get that clients tell attorneys things, and I get that then the attorney has to come up and you have to say what the client's telling you. I get all of that. But I'm telling you, that notion of why that tag's there doesn't fit with anything I see in the police report. Doesn't fit, and maybe in certain relationships doesn't fit with any common sense I know of, but that can happen. But it doesn't make any sense. And now that she's here and Miss Zenta, I'm presuming available to testify before the court, if necessary.
Yes, but if that were the case, I would ask to briefly pass it so she could speak with my victim advocate. And
Understood. I don't know. Well, hold on a second. I don't know if your client wants to change his position on what he's had laid to this court about that air tag.
If we could pass the matter, and I would say to the court that we were not necessarily sharing testimony day. But
oh, I know, and I'm not, and understand that
but
let me just say this. I look stupid, but I'm not. And the problem is that I realize your client has said that to you, you've related to the court. I don't doubt with regard to any contact that you told him what you said you told me. I don't doubt any of that. I'm just having a real tough time believing your client's premise for why that's. And I'm sure, because you have been before me, and one of the things, the worst thing is If you lie to me, we're gonna have a whole other set of problems.
Understood, Your Honor.
So what I will do, knowing that she's here and that I may take testimony, I'll pass the matter. So that the victim's advocate can talk with her, you can talk with your client, and then somebody wants to come and give me a story that makes some sense. Fine, all right? He is to remain in the building, it's not to leave.
Of course, Your Honor.
All right. Is that all I've got for 11? And why is he here yelling at me then? What? He's over there screaming at me, Judge, get moving. I'm sorry, that's what I heard. I don't know. Court's gonna stand in recess.
All rise.
Court recalls case People versus Connor.
As a people, Your Honor.
This time the defendant is offering a no contest plea to the allegation, that being that he's able to articulate the facts, and we would stipulate to the police report as a basis.
Anything else from the people? This time, this is currently set for the ETC, I think this Thursday. So we'll continue the matter to the probable cause conference this Thursday at, is it 23rd? April 23rd, 2026, 9 a.m. At this time, given the admission to the, or the no contest, but admission to the violation, the defendant's bond at this time is revoked. Defendant is remanded.
Thank you, Your Honor. Thank you again for your time.
Thank you, Your Honor.
The people versus Kent Robinson.
Alexander, on behalf of people, Your Honor.
Ron Brown appearing on behalf of Kent Robinson, Your Honor. Your Honor, I've shared
Her name? Kent Robinson. Thank you.
Your Honor, I've shared the pre-sentence investigation report and recommendation. My client, I'd ask the court follow it. We don't have any changes. 125 fines and court costs, 93 credit, 93.
Is there anything you want to tell me before I impose sentence? No. Sentence of the court, $125 statutory fee, 93 days credit, 93, sir.
Thank you. Oh, Your Honor. What'd you want?
With my phone.
This case is over, so this case isn't. Oh, it may be a different case.
What, his phone privileges?
Yeah, you snatched his phone privileges, but I told him.
Snatch him, he messed up.
Yeah, he messed up. And now that the case is over, he should have those privileges restored. Am I correct?
I don't know how many other cases it's on.
He has one.
Whether or not they've been revoked on that case.
So he's saying not on this case.
So
Yeah, they ready.
your camera is on. Let's look at it. Sure.
Court does call the case People versus Ryan Studeville.
Alexander, on behalf of people, Your Honor.
Ron Brown appearing on behalf of Mr. Simpson. Oh, he's on Zoom.
Yeah, he's on Zoom.
Ryan, you got
Mr. Studeville, can you state your name for me?
He's not responding, Judge.
He's not responding, but he's there. What did you want to do on?
I was trying to argue bond, but this may be a critical stage. And I'd ask the court to, he failed to appear for his final settlement conference. So we'd ask the court to set another one of those, because this is a pre-trial, I believe.
All right, but all right. Is it final settlement? Yes, it was final settlement conference. So jury final settlement conference will be set June 5th, 2026, 9 a.m. Jury selection, if necessary, will be June 8th, 2026. at 8:30. Both of those proceedings are in person.
You weren't waking up.
At this time, his bond will continue. You can file a motion regarding his release.
Will,
Bond will continue.
thank you.
All right. Thank you, Mr. DeVille. Court does call the case, People versus Terrence Smith.
And is that on behalf of the people, Your Honor?
Ron Brown, appearing on behalf of Terrence Smith.
Name?
Terrence Smith.
Thank you.
Your Honor, we'd ask the court to set a jury date in this case, and I'd like to argue bond.
Jury final settlement conference will be set June 5th, 2026, 9 a.m. Jury selection, if necessary, June 8th, 2026 at 8:30. As to bond.
Your Honor, I believe Mr. Smith's bond was revoked at his prior hearing on Thursday at PCC hearings. Since then, I've attempted to reach out to supervising agent at Community Corrections to answer questions that the court had concerning the violation. Specifically, my information is that Mr. Smith received word that he had been in violation at 1:50, at 1:58, 8 minutes later, exited the exclusion zone, Your Honor. My information is from talking to Brian Casey, the supervisor over at Community Corrections, that it was the supervising agency that reached out to him, but he was under the misplaced perception that he was talking to Mr. Brian Levitt, the supervising agent, but instead it was JSG, I believe, supervising agent for the Tether company that he was speaking to in reference of the violation and his need to get out of the exclusion zone, in which he immediately did. My further information is that
8 minutes after being in, he got up.
and he was not in contact with the complaining witness. My information is that he went there to assist a family member, a cousin who was moving, and he needed to get some money. And the reason that he went there was to assist in moving. But once he found out that the address that the cousin was moving from was within the exclusion zone, he left. No contact with the complaining witness whatsoever, Your Honor. My further information is that I'll leave it at that right now, other than he needs to get out to assist with childcare. Is that what you told me?
Yes,
Childcare, as it relates to a child in common with the complaining witness.
Yes, sir. Your response, MP.
Your Honor, this is what I'm going to object. This violation of the exclusion zone is extremely concerning to people, given that this domestic violence case occurs at where the exclusion zone is, then he picks up another felony case for resisting and obstructing at that same location. And I have concerns now that he's going back to that area, is there for 8 minutes, and I don't know if he contacted his actual agent rather than just the JSC. It's not in the report, and he was there for 8 minutes.
I attempted to contact the supervising agent on Friday, but was informed that he was out of the office. Again, this morning before court, I went over to Community Corrections. The supervising agent wasn't available, and I spoke to his supervisor, Brandon Casey, and I relayed the information from the notes, I believe, in the supervising agent's file through Mr. Casey. Your Honor?
Yes.
Is he on remand or is there a cash component right now?
Cash component.
Would you consider a cash component?
Not at this time. What I will do is his bond will continue as revoked, given the violations that the court sees. However, I will set a pretrial or a bond hearing for May 4th, 2026 at 12 noon. And you can provide the additional information if you get it.
Would that be can we sign the waiver right now?
Sign what waiver?
Oh, I'm sorry. I misspoke.
Thank you.
He's
Yeah. Court calls the case People versus Michael Clark.
And then on behalf of people, Your Honor.
Hey.
You located your client, have you? Okay, good.
About 3.5 seconds.
Right.
Oops, sorry. Michael, state your name.
My name is Michael John Clark II, Your Honor.
Thank you.
Your Honor, Joe Simon on behalf of Mr. Clark. Your Honor, we adjourned today's date because the people were trying to get some video that we believe will be very relevant to at least one of the two counts. And Pizenda has been on it, but she promised me that that still hasn't been received.
The last I've heard was I emailed, called, talked in person a couple times to Pittsfield, and they're expecting a call from HVA who supposedly has this video this week. So hopefully we'll have it this week. Will be my darndest.
Okay.
According to request in another adjournment of the pre-term.
4th or the 20th?
Up here, both. Oh,
11th?
Yes.
Will the 11th be better? That make one more week.
certainly.
During the matter to May 11th, 2026, 1 p.m. We'll continue. Thank you, sir.
Thank you.
Your Honor, just wait for me right outside.
Calls case People versus Brandon Hargress.
Ready, Your Honor. Alexander on behalf of the people, Your Honor.
Good afternoon, Your Honor. Marcia Craig on behalf of Mr. Hargress, who's approaching. Mr. Hargress, can you please state your name, sir?
My name is Brandon Hargress. Thank you.
Your Honor, if I may, we'd be requesting a final settlement conference jury selection date, please.
Final settlement conference will be June 5th, 2026, 9 a.m. Jury selection, if necessary, June 8th, 2026, at 8:30. Both of those proceedings are in person.
And both those will be here, Your Honor?
Yeah.
Thank you, Your Honor. You have an excellent day, sir.
Court calls case People versus Tanya Hawa.
Alexander on behalf of the people, Your Honor.
Good afternoon, Your Honor. Sam Bernstein with and on behalf of Ms. Pawa.
Your name?
My name is Tanya Bava.
Your Honor, I'm hoping for an adjournment to review the discovery.
4th or the 11th?
4th would be great, Your Honor.
4th or the 11th?
4th, please. Okay.
During the matter to May 4th, 2026, 9 a.m. or 1 p.m.
Thank you, Your Honor.
Bond continue. Thank you. Court calls case People versus Deanna Knox.
Alexander on behalf of the people, Your Honor.
Good afternoon, Your Honor. Charlotte Steffen on behalf of Ms. Knox. Will you please state your name? Tiana Knox, Your Honor.
Thank you.
Your Honor, we're asking to set it for final settlement conference.
Jury final settlement conference will be June 5th, 2026, 9 a.m. Jury selection, if necessary, June 8th, 2026 at 8:30. Both of those proceedings are in person.
Thank you, Your Honor.
Thank you. Bond continue.
Okay.
Court calls case People versus Carmen Foltz.
Alexander on behalf of the people.
Ron Crane on behalf of Ms. Foltz, Your Honor. Please state your name.
Carmen Foltz.
Thank you.
Your Honor, we'd ask the court to set final settlement conference jury selection.
Jury final settlement conference, June 5th, 2026, 9 a.m. Jury selection, June 8th, 2026, 8:30. Both of those proceedings are in person.
Thank you, Your Honor.
Bond continue. Court calls case People versus Gonzalez.
Alexander on behalf of the people.
Ron Pring on behalf of Ms. Gonzalez, Your Honor. Your Honor, she has a fingerprint form that she was ordered to sign.
Okay, that's right. She can file that at the counter.
Okay. I didn't know if you wanted.
I'll take. All right, what are we doing?
Final settlement conference, Your Honor.
Jury final settlement conference, June 5th, 2026, 9 a.m. Jury selection, if necessary, June 8th, 2026, 8:30. Both of those proceedings are in person.
Thank you, Your Honor.
Round continued. Court calls case People versus Derek Allwork.
Then on behalf of
All right, Your Honor, can we pass the matter? He has some documents that he needs to share with the.
I'll pass.
Got him back?
Yeah.
Oh, permission to approach. He just got him back. With the prosecutor.
Jury final settlement conference, June 5th, 2026, 9 a.m. Jury selection, June 8th, 2026, 8:30. Both of those proceedings are in person.
Thank you.
Court calls case versus Derek Williams.
Alexander on behalf of the people.
Ron Brown appearing on behalf of Derek Williams, Your Honor.
Derek Williams.
I have a waiver, trial by jury.
Yes, waiver of jury.
Sir, you signed this waiver of jury form?
Yes, Your Honor.
You understand that you have an absolute and constitutional right to have the matter tried before the jury.
Yes, Your Honor.
You understand that by signing that form, ready to be tried before this court without a jury present.
Yes, Your Honor.
You will also waive their right.
Yes, Your Honor.
Based upon the statement of counsel and defendant, court will consent to have the matter tried before it. Without a jury, non-jury trial will be set for.
May 27th.
I'm sorry. May 27th, 2026, 9 a.m. With its conditions will continue.
Thank you.
Thank you. Court calls case People versus Zachary Harrington.
Alexander on behalf of the people.
Ron Brown appearing on behalf of Mr. Harrington.
Your name?
Zachary Harrington.
And
Oh, sorry.
Your Honor, is this a show cause for fines and court costs?
He owes $14.74. How's he gonna get it paid?
Do you have a plan?
Yeah, I just started a new job at Rampant USA in Coldwater, Michigan. I plan on paying $100 a week until it's paid off.
$100 a week? When are you gonna start that?
Next
Started the job then
next week. I have a full paycheck coming next week.
next week? The
Yes, sir.
20 or the 30th or the 1st, actually. Then what I'll do is I'll put $100 per week beginning May 1st. I'll adjourn the show cause to give me 8 weeks. Give me mid-June. June.
June 15th.
Adjourn this to June 15th, 2026. 1 p.m. And sir, if you're caught up on all the payments, then you don't need to appear.
Okay.
Got it?
All right.
Should he stop at the counter to get ways to pay so he doesn't have to drive down? Either with a credit card.
What?
Stop at the counter to figure out how you can make, so you don't have to drive down here.
Oh, I've made payments over the phone before.
Phone for.
Do it
Great.
online.
Great.
So
For the phone, or you can do it, I think you can do these online.
Thank you.
You can also do it online.
okay.
So if you know how to use, you can get the code or the URL. And you can enter that, or we have a QR code we can get you.
Okay.
What?
All right.
All right?
All right. Thank you.
Here you go.
Yep.